All right. It is my pleasure to introduce Andy Berks. He is an attorney. He is, interestingly enough, has a PhD in organic chemistry from the University of Colorado. He upgraded from LA to New York, and now he's sort of upgrading from New York to Iowa City. He got his
Fairfield.
To Fairfield. I'm sorry, to Fairfield. He got his law degree from Fordham Law School, and he is going to speak today about trademarks and a little bit of IP and a little bit of whatever else you want to talk about. So let's welcome him to Traction Thursday.
All right. Okay, thank you, everybody. I'm actually going to talk mostly about patents. So the title of this talk is The Value of Patents, and I'm going to explain why patents might be of general interest. Patents are especially valuable for people in new product development, or if you're investing in new product development. I don't have investors on here, but these are the kind of things that people who are developing new products really need. And so I'm going to talk generally about intellectual property, mainly patents. I'll touch briefly. Does this have a?
Yeah. Lasers don't work on TV.
Okay.
It won't work on TV, yes.
The pointer doesn't work.
Yeah,
All right. I thought mainly about patents. I'm going to touch on trademarks and copyrights and trade secrets. And I would say intellectual property also involves these transactional matters, and I handle those sorts of things too. So what are patents? Patents were created actually in the 17th century as an incentive to inventors. So there was a time, just a little bit of history that's amusing, when the King of England gave what he called patents to people who would import commodities like into the city of London, for example, like lumber. But that was just a drag on the economy and a way for the king to get a few extra bucks. And so the English Parliament outlawed that in 1624 in something called the Statute of Monopolies, but they allowed patents on new inventions. And so that whole thing developed into a major social policy in the 17th and 18th centuries, to the point where when the US Constitution was written in 1788, patents were part of it. So it was like a big thing in those days. It's one of the few specific things that the Constitution tells Congress, you need to do this. Anyway, the rationale is to encourage the creation of new inventions for the benefit of society. And so the way it works, it's what's called a quid pro quo. An inventor has to give a full disclosure of the invention, and in return, the inventor gets to exclude, if you get a patent, to exclude others from practicing the invention for a limited period of time. And nowadays, the limited period is 20 years from the date of the first filing of a patent application. And the idea is that the inventor, or whoever the inventor assigns the patent to, can profit during this period of exclusion, and that gives them an incentive to make these inventions. And the full disclosure part, that gives other people an incentive to build on that invention and come up with something new. So patents are an exclusionary right, which means that if you have a patent on something, you can exclude somebody else from practicing that invention, but it doesn't give you an affirmative right to do anything. And that's most obvious, like with drug patents. It turns out products like drugs and other regulated products also have lots of patents on them. But just because you have a patent on a drug doesn't mean you can rush out and sell a drug. It has to be approved by the FDA in the case of drugs. So what a patent gives you, though, is the right to sue someone else for patent infringement. So if you have got a patent and somebody's doing the same thing without a license, theoretically you can go to court and stop them from doing that. And so patents protect products and processes that contain eligible subject matter. And so the bottom line here with all this business of the exclusionary right and the enforceability and everything are that patents are an asset. That's why companies like to get patents. And if you're a startup, the patent might be your only asset. You know, you can have an idea, even if you come up even if you go to a manufacturer and have products made, I mean, you may have a warehouse full of products, but theoretically you sell those products and nothing's left. With a patent, you've got 20 years of an asset that can keep on giving. So that's why people get patents. That's the real value. So this is kind of the answer to the question, what's the value of patents? Patents are an asset, a business asset. Yeah, they can be assigned, which is just like a sale of a patent. In the patent world, we call selling a patent an assignment, and they can be licensed, and you can have exclusive and non-exclusive licenses. So I'm going to talk now a little bit about some basics, a high-level discussion of basics of patent law for non-experts, just so you kind of know what's involved if it ever comes up, you're ever interested in it. This is not a do-it-yourself. I'm not going to teach you how to file a patent or anything. I'm just going to tell you like what is involved. So the general idea that I'm going to talk about is we're going to talk about provisional patent applications, non-provisional applications, and filing internationally. And the last bullet point there, getting a patent search, that's actually in the chronology of this sequence of events goes on top, but just I think from a logical standpoint, you kind of want to know like the steps you're going to take, and this is just a preliminary step. So when you first come up with an idea, the proper way to do it is to get a patent search. That's really important because just because you have an idea and just because you can sit there and say, I've never seen this whatchamajigget on the market. It's not on Walmart. I've never seen it before. I can Google on it. Nobody's selling it. That doesn't mean there's not a patent on it. I've seen this many cases that somebody comes up with an idea. In this day and age, I'll get into this, patent applications are published before they're granted. So you can file a patent application. I don't know, I had somebody who wanted a patent on a toy that had a little video screen in the face of a doll-like character. And it was a good idea. It's theoretically patentable. But it turns out, we did a patent search, and it turns out that somebody in Texas, like 15 years ago, filed a patent application, got it published on that exact idea. And it kind of, blew her out of the water. So it's a good idea to get a patent search. You may find your idea is completely known. And because I guess I forgot to mention here, I didn't get to it quite yet. Patents have to be novel. We'll get to that in a second. So there's a novelty requirement. So you can't get a patent on something that somebody else has done. So anyway, getting a patent search is important. Patents have substantive requirements. Yeah, it must be novel. I kind of mentioned that. That means it's new and never been done before. So if, say, you go on a trip to Japan, you see some great product in Japan, and you think, I can make $1 million if I sold this in the United States, if I got a patent on this in the United States. Well, you can't do that because it's already known in Japan. It's not novel. You're not the inventor. It must disclose subject matter that's not obvious, which means a person of skill in the art, that's patent lingo, a person of skill in the art, would not really have combined a few known components to yield the invention. And it must be patentable subject matter. That's a little tricky. That has become a little tricky in the past 15 years or so. It used to be that, anything like kind of technological, if you could hold in your hand or put in a bottle, was probably patentable. That is, like I said, it's become nuanced, let me put it that way, in the last 15 years or so. And the written description requirement, that's what I talked about before, that you have to disclose the invention in exchange for getting the patent, and that allows other people to build on your concept. A little more on the written description. So there's basically 3 sections in a patent application: the specification, the claims, which are the legally enforceable part, and drawings, which are optional. If you need drawings, you got to have them, but some inventions don't need drawings. The specification must describe the invention in detail, and the invention must be enabled, which means that someone else should be able to read the specification and be able to practice the invention, make your thing or whatever, without what we call undue experimentation. So it can't be too obtuse. Provisional patent applications. So this is an interesting topic. I think a lot of people have heard of provisional patent applications, and they probably have heard that, oh, they're inexpensive, anybody can file one, it's easy to do, there's no, and so I'm here to explain to you exactly what a provisional patent application is. And they're there to permit a patent filing with minimal formal requirements. So I just said that a patent has to be novel and not obvious, and that means that there's no prior art, that somebody hasn't done that before. And so by filing a patent application, if somebody did that after your patent application is filed, that's not prior art, so you're in good shape. If there's something published before your patent application, it could be prior art for novelty and obviousness arguments. So by filing a provisional patent application, you get a date that cuts off this prior art. Okay, so you don't have claims or any specific format. A non-provisional application has formatting requirements, but it must contain a complete description of the invention, and you have to disclose all the inventors, and you have to pay a fee. So don't forget to pay the fee. When to file, as soon as the inventive concept is made, prior to any public disclosure. If you're going to a scientific meeting or a trade show or something like that, you've got something new, you want to file a provisional patent application before you do that. And again, that goes to the novelty issue because your own novelty can be used against you. Yeah?
So this is a really tender area because as you know, I work with a lot of startups, and they're raising funds, they have to disclose in very small, intimate groups what they're working on to raise funds. But if they after they go to a conference and they talk to people generally about this, is that disclosure?
Yes, that's a disclosure. So they need to at least file provisional patent applications before they do that.
Okay, what's the consequence if they don't file the provisional? Their own disclosure could be prior art against them. So if you have an idea, if I go in the lab and come up with some new drug or something, and I go and I rush out to the American Chemical Society and give a talk on it, and then a year later I file a patent on it, the patent office will go back and say, well, you talked about this at an ACS meeting, in 2024. You can't file a patent in 2025 because my own disclosure is prior art. So that's an important concept. It's really challenging. So at what point does that disclosure go from a private meeting with a venture capitalist to, going to a conference is public disclosure. That to me is obvious, right? But if it's a private one-on-one meeting with people to vet the idea and get that out, how strict is that? I guess.
That's a little tricky. If it's a private meeting and everybody has a confidentiality agreement, you could say, well, it doesn't count. Okay. But that's still dicey. And I believe, in my experience, investors, venture capitalists, people like that, they don't want to be filing confidentiality agreements. They don't want to deal with that stuff.
Right.
So the way for the inventors to handle that is to just file a patent application. Then they're covered.
Then they're covered. Applications are expensive, and these are startups, and they don't have any money.
It's a business expense.
Yeah.
This isn't like hundreds of thousands of dollars. I'll get into a little bit too, costs later, but it's a necessary expense. I'll just say one more thing on that. There is a grace period in the U.S. Inventors have a 1-year grace period in the United States. So if I stand up here and I tell you, I had this great invention in my garage, I just came up with it yesterday, I would have a year till, what they say, October 24th, 2025 to file a patent application, and I would be okay in the US. But in Europe, I would not be okay. Europe would say, you disclose this to Traction Thursdays on October 24th,
Does that include
2024.
provisional patents?
Yeah.
Okay,
Yeah.
so I have a year. So if I'm working with somebody who comes to me with an invention today, and he discloses it at Traction Thursday,
Yeah.
that person's got a year from that point to file the provisional and all of that.
In the U.S., but
In the
most
US.
other countries don't. That's a kind of a quirk of U.S. patent law, and most other countries don't let you do that. So,
Okay, well, I'm glad they do it in the United States. Thank you.
okay. So what was I saying? Filing a provisional patent application. That's why I say a public disclosure by the invention can be novelty destroying prior art. So we don't want to do that. And filing a provisional in advance of public disclosure. I already have everything we talked about is already on this slide. Here's the fees. A little bit on the fees. The official fee is only $120 for a provisional. That's like nothing really. And if you come to somebody like me, it's going to be a few thousand for me to put something like this together. Anyway, but I add this comment here: spending money up front will save money when it's non-provisional time. And there's some budget alerts here. Because some clients they look at these numbers and they say, oh, great, 120 official fees, nothing, a few thousand for a patent attorney, I'm good to go. Well, you're really not, because lots of things are going to happen. The time frame here, I put 3 to 7 years. That's not uncommon. Even 8 years, 10 years is not that uncommon. And costs will build up. So there is some money involved. It's an investment. I have this bullet point on perseverance. That's a key concept. You can't get a few rejections from the patent office and walk away from it. If you look at patents that are issued, they've often had multiple rejections, and we have to keep coming back and fighting it. Yes.
Looking at your 20 to 30, that's really low, because the two patent officer or patent lawyers that I work with, Shuttleworth up in Cedar Rapids, and then Des Moines one, they gave me $40,000 to tell our clients. So then this is my question: if we know we can go elsewhere outside of Iowa, could that 20, 30,000 be more realistic if they go outside of Iowa? Is that 20, 30 national? Is that 20, 30 what you've seen? I'm just trying to figure out, because if it's cheaper for people to go outside of Iowa and it's still patent's a patent because it's a federal thing, why not go there versus the price tag I'm getting?
Yeah, I can't answer that question. These numbers are wild guesses.
Okay. That's what I was wondering, because I'm like, if that's truly more the thing, it would behoove me to tell people to check other places. Because when we work with these people, they don't have a lot of money to begin with. So when they see that 40,000, a lot of times they're like, I'm going to do trade secret, or I'm going to do other IP ways instead of going down the patent.
Yeah, the thing is, you're not going to get a quote in advance. Right. In advance, no patent attorney, at least no reputable one, is going to say, I'll get you a patent issued for $20,000, no matter what. I've seen people ask for that, although the number was much lower than 20,000. I've seen people ask, give me a flat fee for the whole thing from start to finish. There's just no way to do that, because there's so many unknown variables along the way. The patent applications go to a patent examiner, and the patent examiner, and you can get a good patent examiner that'll say, this is a great idea, you've got a patent. That's happened to me, but a lot of patent examiners just will not listen to reason. It's like a really good invention, commercially valuable, maybe even selling it. And they'll say, oh, some guy in Japan did the first half of it, and some guy in Indonesia did the second half. It's obvious. Any skilled person could have done this and will not give it to you. And then you're talking about appeals, multiple rejections, appeals. And so the cost can build up. And there's no way to predict that. There's no way to switch a patent examiner if you don't like your patent examiner.
Didn't you just get one that took 5 years?
Yeah, I had a client at 6 years. on an invention that I didn't have a lot of faith in it. But I worked at it, and it took it. It got a few rejections, and anyway, I just got it allowed. Okay, and perseverance, that's a critical thing here that I also tell people when they walk in the door. It's going to take time. And the thing with the 20,000, it's not like up front. It's not. So it's just an expense. Okay, so we just talked about provisional patent applications. Provisionals, they only last for 1 year. So you file a provisional application today, October 24th, 24. You have to file a non-provisional by October 24th, 2025. If you don't do that, you're in real trouble. You basically lose that date. And it's very difficult, if not impossible, to recover from that problem. So there's two options I'm going to talk about for filing non-provisionals. You can file US only, or you can file internationally. And just some key features of a non-provisional. They start the 20-year patent expiration clock starts when the non-provisional is filed. So if you've got an invention that has that you think might have a long product lifespan, like a drug, for example, a successful drug could be on the market for decades or hundreds of years even. By filing a provisional and waiting a year and filing a non-provisional, it gives you an extra year. So you would get effectively 21 years from the first provisional file date. But the normal expiration of patents is 20 years from the non-provisional filing date. Non-provisional patent applications in the U.S. at least go into a queue for patent examination. The content is more or less locked, so you can make small corrections, like if there's a typographic error. You can fix that sort of thing, but you can't come up with something new, a completely new idea related to a first invention. There's ways to get around that, which I can talk about later. And also, non-provisional patent applications have formal requirements. There's formatting requirements, like space and a half, a normal font. You don't want Comic Sans font. It's got to be like Times or Helvetica. It has to have claims, and it has to have an inventor's declaration, which is a statement by the person who invented it, saying that they actually invented it. International patent applications can also be important because many patents have international applicability for drugs, for example, or I know a lot of ag people here, crops. These things are worldwide problems, and patents solve problems. So anything you invent is more than likely to work in other countries around the world, but patents have territorial application only. So you can get a patent in the US, a patent in Canada, a patent in England, but a US patent can't be enforced in England, for example. So that's why you might want to get overseas filings. These are, for the most part, nowadays, people use this thing called an international patent application administered by WIPO, which is a UN agency. It's based in Geneva, Switzerland. And they accept patent applications. And there's a nice feature of these international patent applications that you get 30 months after the earliest filing date to start paying extra fees for national stage filings. So the way these work, you file a patent application, you file the international patent application, and it sits around for 18 months actually. And at that point, which is 30 months from the provisional date, you pay national stage fees in any country where you actually want an issued patent. So if you want a patent in Japan, you pay a fee for Japan. If you want a patent in the US, you pay a fee for the US. But that way you just it's kind of all centralized and it's easy to handle. And WIPO does a lot of the back end work. They send the paperwork to all these different patent offices, so people like me don't have to. Anyway, and at this point, it's often a question of budget, because this is where costs can really start building up. And once it goes into the national phase, the patent applications are examined and issued or rejected, just like any other patent application. Just a slide on patent attorneys. Yeah.
Yeah, I was wondering on the filing fees, that does not include the attorneys we pay right now. So like if you did like if you had to hire a lawyer to check for.
No, this fee here, this is just the official fee. So that doesn't include legal fees. Okay, can you file a patent application yourself? Theoretically, you can. There's no law saying you can't go to the patent office and somehow figure out how to do this yourself, but I strongly advise not doing it. I've seen a lot of cases where do-it-yourself inventors like really screwed up a good idea. So it's just something that's not a good idea. Patent documents are legal documents, so you want to have a lawyer, somebody who like knows what they're doing to kind of manage the whole process. And like I said, if a do-it-yourself inventor gets an issued patent, there's a strong likelihood that it will be significantly weaker as a patent than a patent done by somebody that knew what they were doing. And so you have significant risk of losing rights. So the recommendation is get a patent attorney to do this for you. Okay, how are we doing time? Oh, pretty good. Okay, I just have a couple of slides here on other forms of IP. Trademarks. These are intended to indicate the source of goods and services. So this is the kind of thing like, some people like Coke, some people like Pepsi. The issue there is the trademark. If you like Coke, you're looking for the Coca-Cola trademark. If you like Pepsi, you're looking for the Pepsi trademark. So it gives you, when you go into a store, it gives you the warm, fuzzy feeling that you're buying what you think you're buying, not some generic copy. I mean, some people may be okay with the generic, but, the Walmart brand, but a lot of people are not, and for some products, you may want the real thing. So anyway, this is what trademarks are for. In trademark names, this is the trademark name. The standard is distinctiveness. So it has to, trademark names should be distinctive. That's the general idea. So if you think of some of the trademark brand names that we know and love, or maybe not so love that much, but like Exxon gasoline. I mean, Exxon's not a word in the dictionary. Even Coca-Cola, that's not really a word in the dictionary. And secondary meaning, I'm not even going to get into that. But these are just some common trademarks. Coca-Cola, Microsoft, McDonald's, Nike, these sorts of things. For some reason, I got involved in whiskey bottles, but on this slide, I made this slide up a few years ago. But these are also trademarked. I don't know, people who drink bourbon whiskey, maybe they love Jack Daniels. They don't want Walmart brand bourbon. They want Jack Daniels, so they know to grab the Jack Daniels trademark.
What's the difference between trademark and circle or
What?
registration marks? What is the difference between registration marks and trademark?
Oh, so that's a good question. The question is, what's the difference between a registration mark and a trademark? So actually, trademarks, I don't have an example up here, but sometimes you see a little TM next to a trademarked word. That means it's not registered. And the little R in a circle, it may be a little hard to see, but this is a little R in a circle, that's a little R in a circle. The little R in a circle, that means it's registered. Okay, so
It's official.
yeah, well, you pay a fee. A trademark examiner does look at the application, and you get a registered trademark. Yeah, but actually, and getting registered trademarks is, if you've got a valuable brand, is a good idea, but you actually have a lot of rights just by putting a TM on something if you think it's a brand name, because there are words and phrases that you may think are very distinctive, that distinguish your brand in the marketplace, but that are not trademarkable at all because they're not distinctive. Like I was talking about distinctive, they might be, it's what's called descriptive. You know, if you just like, you know, what's descriptive? Hamburgers. Hamburger's descriptive. You can't get a trademark on a hamburger if you're actually selling a hamburger. Now, Apple got a trademark on computers because computers are not actual apples like that you eat. But you can't, but if this was a trademark for a food item, that wouldn't work because it's descriptive. So, but you could still, but somebody who thought they had like a great logo or something could put a TM on it, and it still gives you a certain amount of rights. And in some cases, you may even be able to sue somebody for infringing that mark. And also, over a period of time, you can get what's called secondary meaning, which may allow you to get a trademark registration after 5 years. So there's anyway, there's some lingo there, which I didn't get into, but you asked about it, so I'll tell you. Copyrights protect the expression of an idea, not the idea itself, and this is used for artistic kinds of things like written materials, books, magazines, newspapers, visual arts, painting, sculpting, music. These are all copyrightable things. Trade secrets. This is, trade secrets have some overlap with patents, but the most commonly litigated issue in trade secrets is customer contact databases. So if you're like, say, working in sales for a company and they've got a list of customers and you leave that job and you take that list of customers with you, that could be a problem. And the, you know, companies, people have been sued over that sort of thing in the past. A trade secret is anything of commercial value that requires effort to acquire, and I forgot to write it there, you keep it secret. You have to keep it a secret. The thing with trade secrets, why they're risky, is because reverse engineering is a defense. So if you've got, you know, a customer database, and you actually go out and find those people yourself, or if you've got a black box like this thing right here, you know, if I didn't want to get a patent on this little clicker thing, and I just hold it as a trade secret because it's a mysterious black box, I don't know how it works. It's just got Bluetooth or something. But if I reverse engineer it, you know, take it apart, or maybe not even take it apart, I just say, oh, there's 2 buttons on it. I can design my own gadget with 2 buttons. That's reverse engineering it, and that's a defense against a trade secret accusation. Okay, well, that's the end. Thank you.
Questions.
You didn't talk too much about plants. I didn't hear you say anything, but suppose you find somewhere some plant that has marvelous food possibilities and you want it to be publicly available for anyone, and you want to prevent somebody like Bayer or one of the other big seed companies from somehow, you know, swooping down and making off with it and making all the money themselves and leaving anybody that wants to acquire it having to pay a lot of money. Is there any way you can protect against that?
There is a thing called a plant patent.
I know.
That maybe that's what you're alluding to. I haven't really gotten involved in that. That is an extremely specialized subject. And there's only a few hundred or a few thousand at the most filed every year, maybe even in the past 20 years. So, but as a food item like that, if it's patentable subject matter, you could get a patent on it and you could just dedicate it to the public, which means that if a big company like Bayer or Monsanto, if they still exist, comes along, they wouldn't be able to exclude other people. So
their might, getting the best lawyers in the world,
yeah,
and sort of
Yeah.
outspending you on lawyers.
and actually, what you could even do in that is file a patent. I guess I kind of skipped over it, but a non-provisional patent application nowadays is published in the United States and most other countries 18 months after the priority date. So you could file a patent application and then just walk away, and it gets published, and then walk away from it, and it's out there in the public. So, Bayer would not be able to go in and get a patent on that.
If I were to look for a lawyer who could help me with that, what would I Google?
What would you what?
How could I find the lawyer who could help me with that?
Give me a call. I'll help you.
Well, hey, so Andy, if David goes to the Ecuadorian jungle and finds some completely novel plant that no one has ever heard of, but it comes out of the ground, not out of his brain, is that patentable?
I would say no. If you just find a plant in the jungle, the plant itself wouldn't be, but a food product extracted would. Like if you cooked it, if you did something to it, you'd have to do something to it.
Wouldn't you'd be able to patent the bioactive in that plant for a certain use case? Correct?
Yeah, that would definitely be patentable.
Right.
So if you had a plant from the jungle, if you found a plant in the jungle, because actually people do this. I even worked for a guy once who was extracting chemicals out of seaweeds and sponges. Those things are patentable because you're extracting it. There's work that goes into it. But the plant itself, that's a little bit of an issue. That might not be patentable. Yes.
In my work, in my side hustles and stuff, I do a lot of research into copyright. And what I do is I go to the USPTO website and I put in what I'm trying to create something for, and then it tells me if it's a live trademark or copyright. And just to tell a quick little story, I once had a brilliant idea for a T-shirt that said "In this moment," and it had this lovely little poem on it, and I was going to put it on a T-shirt, built it, put it up on Amazon, and immediately there was a copyright infringement on it. So then I went back to this site, and that phrase, "In this moment," actually has a live trademark on the phrase.
Oh, interesting.
Yeah, so those of us who are creative and trying to think of names for things and taglines for things, you really have to check this before you actually start publishing. Yeah.
There's even a better website than the USPTO that WIPO runs, who did the patents, because they also have trademarks. They also do trademarks called WIPO brand database. Just Google on that WIPO brand, because they have all the U.S. marks, and they have marks for like 100 other countries around the world. Yeah, one thing that's kind of interesting about all this subject, I told you like patents were cutting edge social policy in the 18th century. Nowadays, like virtually every country in the world has a patent law of some kind. Even these podunk places that are like really poor countries in Africa and, the Pacific Islands and things like that, they've all got patent laws. So I don't know if that's all because they all use the same consultants to write their government rules, but they've all got them.
So Andy, you're right here, and many lawyers are elsewhere. If someone wanted to just set up a time, they have a question or they have an idea, how do you generally engage with people? When do they start paying you? I guess as all of us starting entrepreneurs here.
Well, after an initial consultation, if I start doing work, I will bill for it. Yeah. I personally usually do initial consults for free, but even though when I got divorced, I I paid for initial consult. But I usually do them for free. And anyway, so, but after that, like the patent search and things like that, then that's where the money starts to come in. Yeah.
Question for you. So it's kind of dual. When we're working with people who are wanting to get a patent, we tell them to get a lawyer. But what can we prepare them, or what can we, and even if anybody in general wants to get, what can they do before to make sure that it's a good meeting and not just, here's my story. Like, what do you need, or what would an ideal client coming into you have this ready for you?
That's a good question. An ideal client knows what's in this talk. Has some idea what a provisional patent application is, what a non-provisional is, some vague idea of the prices. I said it, like when I said 20 to 30,000, that was a wild guess. We're talking orders of magnitude. So in my mind, 20,000 is pretty much the same as 40,000 because it's in the same order of magnitude for that sort of thing. So, just this basic information, knowing to go to a lawyer and get a provisional filed before a public disclosure, so we're not.
Can you give good advice if someone had an idea and they presented it to you? Would you have wise counsel about whether you really thought it would go or not go?
Yes. That's what I would do in an initial
And you're very honest about that. Because I've heard horror stories of people who spent tens of thousands of dollars and just got screwed on patents.
Yeah. Because I've had people come to me. I had somebody come to me once with an idea for something to pick up dog poop, okay? It was like a little cloth that had, pull ties. So you would, like, the dog would poop in the paper and you'd like pull it tight and just throw it out. And I said, well, that's a good idea. I always tell people it's a good idea because they always are good ideas. But, I've done this long enough that I get an intuition of like what's patentable and what's not. And I said, I can't believe somebody hasn't done this before. And so I did take a fee from them to do a search, and I found that exact thing. So and I've had several cases like this of people that come. The good ideas, they tend to be simple things, not especially technological, but if somebody's done it before, you may as well not spend the money.
When you're doing a search for someone, what do you charge for that?
Usually 1,000,
Okay.
1,000 or
These
1,200.
databases are expensive.
Yeah, because I pay for a premium search service that's better than like the Google patents.
Yeah, and I can tell you, using other lawyers, that's on the low side.
Yeah.
From what I heard from other lawyers in Des Moines and Cedar Falls, or Cedar Rapids. So,
Why are you telling me?
well, I'm telling you guys, use him. Use him. Right. It's on the low side because it's a great service here that if you want to know something that's reasonable, just saying, just.
We're going to have to do a search in your bank account after this to see if you're not on his payroll. Could you just quickly, you may have mentioned it, but the just brief difference between a design patent and a utility patent?
Okay, I didn't even mention design patents. So design patents are a little bit like trademarks. They cover the look and appearance of something, but it's something, like you could get a design patent on this thing right here, but it would just cover the appearance of it, not the functionality.
Not the functionality.
Not the functionality, yeah. And they're less expensive to file. You're basically only filing drawings. There's no, the so-called specification is just, I have a new design for a PowerPoint remote control, and as shown and described, that's what they say.
Yeah. Okay.
As shown and described, and it's just drawings of this sort of thing.
Right. So if it was round as opposed to oblong.
Yeah.
Okay.
Yeah, shoes are real big. And those can be really valuable patents. Like some of the Apple and Samsung patent disputes over smartphones were on design patents. So, and they were billion-dollar problems.
Yeah.
Yeah, I think Samsung had to pay like a $5,000 fine in Korea. It was pretty funny. But the in terms of design patents, I just think because I work in a lot of VR space and I see a lot of movie stars and things starting to look at how do they patent their own likeness so that it can be used posthumously. Have you seen like anything? It must be a pretty interesting debate. So I'm just curious.
I haven't worked in that area. I'm sorry, I really don't know a lot about that. I was just reading something in the New York Times just in the past few days on what do they call it?
Name, image, and likeness.
What?
Name, image, and likeness.
Yes, name, image, NIL. Yeah. Name, image, and likeness for college athletes. So, but I'm that's that's sort of an intellectual property, and that'd be more like copyright. And so that'd be more of an entertainment lawyer would be more into that. I know people who do that. If you want.
That's interesting. We have time for one more question. John.
Yeah, I've got a kind of a thorny question, not about my patent, but about my trademark. So I got a trademark for the word floating bed because when you're on my bed, it feels like you're floating due to the way it interacts with your vestibular system. Then, and then there were some issues, but I got through that. But then individual people, for the most part, like a carpenter, started making beds with a hidden leg. And they began calling them floating beds. So these are not companies that I can go after. They're just thousands of people. And now they're taking the first few pages of Google. There are a tiny amount of companies using the word floating bed, but they're not significant, really. So there's probably nothing I can do about that, right?
I mean, you could send cease and desist letters to these people, and theoretically...
1,000 times.
Yeah. I mean, theoretically... If they had significant products, you could go after them. But, I mean, one way to do that is to come up with a logo, a graphic that they wouldn't use. Something to distinguish yourself on the marketplace.
The original. The official.
John, that's actually happened with us with Wiffleables, and we've got a templated form letter that we have cease and desist because because somebody's going to say, "Oh, Wiffleables is a cute name," and they do it, and they don't even know we exist most of the time.
There are just too many.
There's just too many in your case. Yeah.
But this idea of the logo is good, and I'm working on that. So
Good.
thank you.
Yeah, you can register the logo, and that'll help.
Right.
Because then people will know that they're buying your bed, not, the bed from some schlemiel out in the country in Iowa.
I can honestly say that this, Andy, might be the most valuable presentation we've had because we've spent 45 to 50 minutes with an attorney and didn't get a bill. So let's thank Andy for the bill is in the mail. Let's thank him again for your time. Thank you very much. It was awesome.